members.
Recording in progress.
Team from the department, the leadership of the entities as led by the boards and the council of ICASA in particular. Fellow South Africans who are following us in the different platforms. As I greet this morning, honorable members, we are indeed meeting today as part of our robust oversight that we need to play over the executive as well as the entities that report to the department. And in this regard, we would be having ICASA as well as USAASA, USAF on matters that may have come before the committee, but as a way of follow-up and ensuring that action plans that get presented before the committee, we have a way of following up that there is implementation in that regard. Of course, it is also an opportunity for us to be taken into confidence on matters that are of public interest, but also of interest to the committee as we play our oversight role. So this would be my brief opening remarks before we deal with the formalities of opening up the meeting. Just as a way, honorable members, as well as participants on the platform, just to remind ourselves of the rules applying in the engagement on this platform, virtual meetings. We are reminded that at all times we have to ensure that our mics are muted, as well as video cameras switched off, unless you are recognized by the chairperson. In a case where you need to speak, you then unmute your mic, as well as switch on your video camera, so as to ensure that the viewers home also are able to link the speaker to the face. That's helpful. But of course, in a situation where a member or participant is experiencing connectivity challenges, you would indicate that to the chair and ask that your video camera be switched off so as to maximize the bandwidth, but also to ensure that we can still hear you in terms of the contribution you're making in the meeting. Otherwise, under normal circumstances, would really urge members or participants on the platform to ensure that every time they're on the platform, the video camera is on and you'll then unmute your mic. Because of connectivity challenges, people may lose connection and may have to reconnect to the meeting. Ensure at all times as you reconnect to the meeting that your mic is muted, as well as your video camera is switched off. This is also to ensure that background sounds that could be picked up by mics, as mics are sensitive, that does not distract the speaker that may be on the platform or take away the attention of members from the speaker that may be on the platform. As a guide, we're also urged not to have unnecessary point of orders that may collapse the meeting on this platform. However, in a situation of point of orders, of course, members would not be switching on video cameras and unmuting the mics unless they are recognized by the chair. In that score, the chair would then allow the member to unmute the mic and raise the point of order on which the chair may also rule on in terms of the rules. If we keep that, honorable members and participants, that should help our meetings to run smoothly. So I will, without waste of time, for purposes of formality and record, check with the committee support staff if there are any formal apologies that may have been received, so as to place those on record. Committee support.
Good morning, Chairperson. We have an apology for the Minister who's abroad and also the Deputy Minister who had an emergency. Then we have apologies for Mr. Gumbu and Ms. Majosi. Thank you.
Okay, those are the apologies that have been received. May I just check if there may be apologies members may be aware of that would have been forwarded and may have not been placed on record. The Honorable Bodani.
Good morning, Chairperson. I'm following up with Honorable Malati. I know he has connectivity issues.
Okay. Thank you, Honorable Bodani. Those are the apologies that we have, and therefore you're all welcomed, honorable members, and we can now proceed to the next item because we have a correcting meeting to proceed. As I would have said, we have those items as flighted for all to see. We have a briefing by ICASA on spectrum auction finalization and future regulation, which will then be followed by a briefing on USAASA, USAF, on framework and timelines on all current investigations and implementation dates for consequence management processes. We will then, after that, take a discussion and then adoption of outstanding minutes. I will then, without a waste of time, having received an apology from the Minister and Deputy Minister, as it is the norm, we'll usually give the political heads to also take us into confidence as the committee on matters of public interest. In this case, I take it that the department will play that role in introducing the entities as well as giving us an overview on the items before us. Thereafter, we'll then give the entities starting with ICASA, as led by the chairperson of ICASA, Dr. Modume, would then indicate how they are approaching the presentation. Would also then, after that, take the USAASA, USAF as led by the chair of the board. I'm trying to check because I did see the chair of ICASA switching on the video camera, so I could easily identify. I take it at the time that the department speaks will also confirm if it's the whole board of USAASA that's here led by the chair, and they will present as such. So after the department, I take it for both ICASA and USAASA, it won't be a problem. The minutes that would allocate would give you 25 minutes maximum. Of course, if you can do it in less than that, that would be fine, taking into account that members may have received the presentations on time. They would have gone through them. In any way, further clarities would be at the time of engagement. I hope that's clearer. The department, if you can now take platform and you'll then indicate how the presentation is approached. Is that acting DP? Yes, you are recognized, Mr. Shalembe.
Good morning, Chairperson, and good morning to the honorable members. Perhaps I need to register the apology of our acting DG, who is also out of the country. And I'm here therefore in the capacity as the acting in that position. Chairperson, I do not see my video here. I hope you can see me.
Yes, we can see you. Mr.
Thank you very much. First of all, Chairperson, we will represent ICASA, who will be presenting on the spectrum auction finalization and the future regulations. Just a brief overview, Chairperson, on their presentation. ICASA initiated the licensing of the International Mobile Telecommunications IMT radio frequency spectrum by means of an auction, aimed amongst others to deal with growth in demand for spectrum as a result of significant growth in traffic for broadband services. The main auction stage was opened on the 10th of March 2022 and subsequently concluded, Chairperson, on 17 March 2022 after multiple rounds of bidding held over a period of 6 days. In aggregate, that process raised 14.4 billion for the billion for the fiscal. ICASA has since issued radio frequency spectrum licenses to the successful bidders after receiving the proportional payment of the auction fees. The process for the connection of various public institutions by licensees as part of their social obligations is now underway. So, Chairperson, the submitted presentation highlights the applicable spectrum licensing regulatory framework, the various stages of the licensing process, the auction outcome, the issuance of the radio frequency spectrum licenses, as well as a future regulation. Maybe as I end, Chairperson, I need to just highlight that there's still a matter in front of the Constitutional Court, which was heard on 20 May 2022, after the ETV filed an application for direct leave to appeal against the Gauteng High Court division, which had found, amongst others, that the minister had the authority to determine the analog switch-off date without consultation with other stakeholders, such as ETV. But that court had extended the analog switch-off date from 31 March 2022 to 30 June 2022. The impact of the case, Chairperson, should the analog switch-off date be extended to a later date, will result in the spectrum currently being used by broadcasters, which were sold to mobile operators, not being able to be used by those successful bidders until the analog switch off is given effect to. Judgment is awaited on this matter, Chairperson. That would be all on ICASA as an introductory remark, Chair. I will then move on to make an even brief introduction on the presentation by USAASA, which is on the framework and timelines on current investigations and implementation dates for consequence management. The presentation by USAASA and USAF, Chairperson, is divided into three. It covers three areas. The one is on disciplinary investigation on the 6 suspended employees. The second one is litigation and arbitration matters. And lastly, investigations by National Treasurer. Chairperson, as the department, we have implored USAASA to undertake, but also to try and finish these matters expeditiously and in a cost-effective manner, so as to ensure that the interest of the entity and the fiscals are protected at all times. Without further ado, Chairperson, I will then, with your permission, invite ICASA to come on board and start off with their presentation. Thank you very much.
Asta.
Thank you very much, and greetings to Honorable Chair Maneli and the honorable members, and greetings to all the colleagues on board. We would like to then take the committee through our presentation. It's actually brief, given the fact that we do appear from time to time, so we'll just focus on the salient points. We can go to slide 5. So as we all know, that ICASA has indeed, after serious delays in the past occasioned by a number of factors, has finally managed to license the high demand radio frequency spectrum through an auction. The auction was successfully concluded in March of 2022, and licenses have been issued. Just by way of background, I think we all know that spectrum is a finite resource. It requires prudent management on behalf of the public. It belongs to the people of South Africa, and ICASA is just the licensing custodian. But the spectrum is a resource that belongs to the people of South Africa. And in us licensing it, we need to ensure that we do it in a manner that is in the best public interest. We licensed the following bands: the IMT 700, 800, 2600, and 3500. We balanced this particular licensing to ensure that there is the sub 1 gig spectrum, which is very good for wider coverage, which is around 700 and 800, but also the upper bands, which are good for capacity. So we tried to really bring about the balance in how we went about this licensing. Next slide. I think I would just touch briefly on the objectives, of what we really were looking at and will continue to work towards, is the promotion of broad-based Black economic empowerment, the universal provision, connectivity for all, the development of SMEs to encourage investment and innovation in the sector, promote competition, and show efficient use of radio frequency spectrum. I mean, just by way of an example, the one that talks about encouraging investment and innovation, on the back of this spectrum auction, as a matter of fact, 2 ratings agencies, Moody's and then Standard & Poor, have changed South Africa's investment grading, at least an adjustment. And the spectrum auction has been cited, formally as one of the cardinal achievements that led to that credit rating adjustment. So I'm just mentioning this to give an example of what we mean when we talk about encouraging investment in this regard. Now, the 6 participants, the process, I must say, was open to everyone who has a network service license. Everyone who had a network service license was allowed to participate, but the applicants ended up being Cell C, Liquid Telecoms, MTN, Telkom, Rain, and Vodacom. So those were the participants in this auction. Next slide. We went through a stage. I think there's various stages that we undertook, starting on the receipt of applications. We went through qualification assessments in February. We issued qualification letters to the applicants. We then did bidder training and mock auctions to make sure that the participants are ready. That was around early March. Around the 8th of March, we did what is known as an opt-in auction. It was a scheme designed to accommodate the relatively smaller players, if we can put it that way, in the market amongst the 6, so that they could also then have a first bite of the cherry, understanding how our market is, the market dynamics. We needed to ensure that we accommodate the the relatively smaller operators. They participated in an opt-in. It was a sealed bid auction, and it was held at ICASA's offices. And then 2 days later, we went on the 10th of March into the main auction stage, where then everyone was able to participate. It was in the form of an online multiple round auction. And we then, of course, customized the auction software with our consultants, and everything was tested accordingly. And on the 17th of March onwards, when the auction concluded, we then started the process of assigning the successful bidders with the relevant spectrum. Next slide. The result in the opt-in round, the successful bidders were Rain and Telkom in a number of lots. The total amount was just close to 2.7 billion rands, just over 2.6 billion rands. We fetched that amount in the opt-in round. The participants in the opt-in round were Rain, Liquid, were Rain, Telkom, and Cell C, but the successful bidders rather ended up being Rain and Telkom. And as I've said, we raised about just under 2.7 billion in the opt-in round. Next. The main auction, all 6 participants, they played a role. I think we are trying to depict here with various colors that they all bought. Vodacom got something, about 20 in 700, and then MTN got 20 in 800. There was an unsold lot of 800. It was called lot 9. Also in the sub 1 gig, it was unsold. We understand that the reason why it was unsold was because of the obligations attached to it, but it's not a problem because this unsold lot is part of the settlement we have reached with Telkom. We were the main litigants that we will embark on a process of openly accommodating everyone, openly, kickstarting a process to license this unsold lot. So I just thought I should make that point clear. And then, of course, the participants bought also in the 2600 megahertz band. MTN bought, Rain got, Vodacom, and then in the 3500, Cell C got something, Liquid Telecoms, and yeah, so there's just a good balance, and Telkom also got in the 3500. So there's a good balance. Operators or participants bought spectrum according to their operational and commercial needs, and that's the beauty with an auction, because it gives you an opportunity to really bid for what you want and for what you are really prepared to pay for. Thanks. Next. As I've said, there's a lot that was unsold. It was called lot 9 in the IMT 800. And as I've said, we had attached obligations that related to nationwide population coverage of 99.8%. So I think operators or bidders were spoiled for choice. That's why they could perhaps on this particular auction stage, decide to leave this one out. Given the fact that at least there were other pockets of spectrum they could bid for. But when we went on to the auction, honorable members would recall that ICASA had, through economists and everyone, ran an estimate of about a minimum of 8 billion rands. And we are glad to have raised in excess of 14.4 billion rands with an unsold lot. For the first time that an auction takes place, we have far exceeded our estimates, and we still have value because the unsold lot can only be licensed in a competitive, fair, and transparent manner. And that manner can only be through an auction, which means there is value. We surpassed expectations and we still retained value. We can move on to the next slide. Licenses have been issued to successful bidders. We are just finalizing, the payment with the last with one operator who has paid in part. They have advanced, but we just at the tail end of closing up on that payment issue. But as matters stand, everyone else has paid and licenses have been issued. And there are social obligations which relate to connecting public institutions, clinics, police stations in their hundreds, clinics in their thousands, traditional offices across the country, government, hospitals, in their hundreds as well. So these are the obligations. It's not only a question of buying, procuring the necessary relevant spectrum, but there are certain obligations for meaningful efforts towards bridging the digital divide that the successful bidders understand they need to then adhere to. We are working very closely with the department in this regard so that we can do. Then there's future regulations. We have embarked on a number of regulatory interventions. These relate to the draft outlook on the long-term spectrum outlook for 10 to 20 years. It's also at promoting efficient use of spectrum, trying to meet the growing need for capacity, which is exceeding the available spectrum. As I've said, it's a finite resource, and to try and really help with market certainty. We are working on dynamic and opportunistic spectrum access. This, it's currently underway. We are working on regulatory framework, which was completed, and we are now implementing the registration and usage process. Research is ongoing in this regard. We're working on the forward-looking conformity assessment framework for type approvals. This talks to the assessment, conformity assessment of products as we approve them for safe use in the markets. Honorable members would from time to time at their homes, observe that certain devices in their home, be it decoders, would have an ICASA sticker. It's a small ICASA sticker on when you buy a new mobile phone, on the box outside, there's an ICASA sticker written TA and a number. That's a type approval number. It shows that that particular device has been approved for use in the country. It's safe. It's not a counterfeit good and so forth. So that's what type approval refers to. We are now working, we have closed on the final equipment authorization regs. The regulations will be effective once the guidelines are in place. So that's what we are now working on. We are working on, as part of future regulations, the radio frequency spectrum assignment plans for IMT as well. We are in the process of consulting, and we aim that through this consultative process, we should be able to release an additional 200 megahertz of spectrum. We hope to conclude on this by the 31st of March, 2023. In the international fora, we have the World Radio Conference coming in 2023. It's a big conference. The last one was in 2019 in Egypt. The next one will be in 2023. That's where even the new spectrum that's ripe for licensing will be identified by the ITU. There is currently in Kigali, the World Telecom Development Conference. It's currently taking place in Kigali. We have a delegation that's currently attending. It's quite an important conference as well. There's a number of participation on ICASA within our SADC region as well as ATU. The next slide. Yeah, so I would then like to close off and by addressing the issue of the wireless open access network, the WOAN. As we know, that policy directive was issued by the minister in the past, I think about 2 years or so ago. And that particular policy on the wound made it necessary for us to license spectrum. The one part was through an auction, the other part was through a pro-transformation tool called the WOAN. Having embarked on this process as ICASA around November last year, we realized that there was always a linkage, especially from a litigation point of view, wherein the WOAN was more often than not, engulfed in the litigation that related to the licensing of the spectrum through the auction. Now, as a result of that, and also considering the fact that other jurisdictions which the WOAN model had fundamentally been benchmarked on, encountered certain challenges. We thought it very important and prudent for ICASA to pause, to embark on a process that would allow us to strengthen the WOAN business case. There is no use licensing a WOAN by just going through the motions, licensing the WOAN for failure, or licensing the WOAN in a way that places unjustifiable obligations or burdens on incumbents either. It has to be a properly balanced thing that we know will be embraced in a healthy manner by industry. It will be supported so that it does not become a monumental failure. Whilst we are doing so, just at the commencement of auction, Cabinet announced that there is a relook, I will use the word relook, on the WOAN policy to, I believe, also try to enhance its business case, and there will be further communication in that regard. And we really believe that the policymaker, who is the minister, as Cabinet has announced, is busy looking at the best way of enhancing the WOAN policy. Once that is done, which will take form in a public consultative manner, ICASA will participate. We would urge everyone to participate in that process so that whatever outcome we yield from a WOAN perspective should be an outcome of public consultation. So as ICASA, we have already engaged. I mean, I can divulge that we have had a series of engagements with the Mexican regulator who have implemented something similar to the WOAN model. We are engaging with, even on the sidelines of the conference in Kigali that I've just mentioned, we have a delegation that will be looking into engagement with other regulators on what may be or have a semblance of the WOAN model in their countries. It might not be called a WOAN, but it might be something similar. I think it is quite important that we need to learn from the successes yielded on the auction side, that sometimes it helps. More often than not, it takes time for us to arrive where we want to be or where we want to arrive, but it helps that we ultimately arrive with all stakeholders, with the buy-in of all stakeholders on board, because we have now learned that indeed, not that we didn't know, but now we know, we are indeed in a constitutional democracy. Anyone who's aggrieved has franchise to approach a competent court of law. And this has a very serious bearing in halting processes, especially in instances where we may be seen to be cutting corners. So that's why I will leave it. ICASA is still committed to the WOAN. It has to be done properly. All formations that have a view on WOAN and how it should happen, we urge them to participate in formal processes whenever those formal processes are opened, either by the minister, the department, by ICASA, because, honorable members, it's important that we subject our inputs to formal processes. I think let me leave it at that. Thank you, Honorable Chairman Eli. That's the end of our presentation.
Thank you, Tasma. I'm just checking if the board chair, Ranto, from USAASA itself.
I'm here, Chairperson.
Okay, then you can proceed with regard to your presentation. Thank you.
Thank you, Chairperson. Chairperson, I'm not going to open my video because the background of me is a hospital bed, so I wouldn't want you to see the background and traumatize you. Chair, good morning to you, Honorable Chairperson. Good morning to the members of the Portfolio Committee. Good morning to the department officials from the entities, the management from the entities. Good morning to my colleagues and everybody else who is listening to this meeting. Chair, USAASA is going to present a timelines and framework of investigations that are currently implemented, the dates and consequence management processes. We've got 6 cases in USAASA that we are looking at, Chair, and those cases, some of them are in front of the courts. We wished as USAASA to have completed these cases long ago because they are from 2016, 2017, but because other cases are in front of the court, so the courts are taking their time to complete the cases. There is nothing that we could do, especially at this time that we are winding off. We would wish that before we wind off the organization, we would be done with the cases, but it all depends on the court processes that we are looking at. The CEO, Ms. Madikizela, will introduce the presentation, and I think Mr. Mngabisa will take over and present if he is around. I can't really see who is in here and who is not, but I know that the CEO is around. The CEO will, the acting CEO would give the presentation, and if Mr. Mngabisa is around, Mr. Mngabisa will then conclude the presentation. Thank you, Chairperson.
Good morning, Chair. Good morning to all the members, the chairpersons of the boards, and colleagues and the likes. Chair, we are going to, I think Chair has given, the chairperson of the board has given a preamble with regards to our presentation today. Our focus really would be on the labor related matters, including what is sitting in the courts, various arbitrations and litigations bodies, and that we are currently faced with, Chair. So we'll start with the labor matters, Chair. Yeah. And just to give a brief overview of that, you can go to the next slide. We suspended 6 officials in the entity due to some financial possible financial misconduct that was discovered during an audit period when we did an open review. Sipho, if you could just move the slides, please. Chair, the actual, so the 6 cases, we had aimed to have completed this as per our policy and our framework that then details that we need to have completed these various cases within 90 days. However, due to the complexity of the matter, which the policy allows, we have not been able to conclude. We've had, Chair, some disruptions with regards to the bodies that were investigating these 6 matters. And due to those delays that came with other people having resigned and retract their appointment, we then are currently in the process of concluding these matters, Chair. What we aim to have done, or what we aim to do, is to conclude these matters before beginning of Q2. We're currently at very advanced stages, and it is really comforting to know that we, after such a long time, we've come to the tail end of these 6 cases and the suspended officials. Chair, this wraps up basically the consequence management component of our presentation. We'll move then to the litigation. Next slide, Sipo. Chair, we have various matters that are currently sitting in the courts, I guess, and emanating really from the procurement of the STBs that were procured. And Chair, due to the nature of the tendering process and a tender of this magnitude, it is an environment that is very litigious, and therefore all of these things emanated from there in the main. We have cases with installers when we contracted various 27 installers that are linked to currency exchange cases, also links to fluctuation cases of based on contractual basis. We also have a broadband related matter, which Chair, I must also allude that we are in the process of trying to resolve that even outside court. We've written to the attorneys there, and we are really trying, and the whole point of this, Chair, is for us is to try to mitigate some of these matters from going forward wherever we see that we could resolve them. And Chair, I must also just put a disclaimer that since these matters are sitting in the courts, then we are also sub judice in terms of answering some of the questions that could potentially causes problems with the related cases. Next slide. And just to take you through the cases themselves, we have a case against the VBS Bank and USAASA. The claim is for 102 million. This claim, Chair, was paid. It is discovered, or it is purported that the CEO at the time of USAASA had then entered into some agreement to say that all the invoices linked to this service provider will be paid by USAASA. In our contractual agreement with Lerata Dima, Chair, we contracted Lerata Dima and not VBS Bank, and therefore we continue to fight this case because all the monies that were urged to be owed to VBS Bank were indeed paid to the account of the service provider that was provided to us by the service provider. So this matter was deliberated in the court on the 13th of May, and currently the judgment is reserved in this regard. We can move to the next. We also have matters related to the same service provider, which is Lerata Dima, in the main being the 3 cases, Chair. If you can just move the slide. In the 3 matters, Chair, linked to Lerata Dima, I thought I would just club these together and just report on under one. Lerata Dima was indeed a service provider that we appointed for the manufacturing and distribution of set-top boxes. And then during that time, Chair, the parties, we then agreed on, due to various issues that emanated related to stock and the feasibility of stock, it being in the various warehouses. We then got into a claim, Chair, where they're claiming that the invoices were not paid, yet USAASA is saying that we could not validate that they had given us or delivered all the related set-top boxes to that. So that claim is related to that, and we continue to pursue the matter. The matter was heard on the 9th of May in the High Court, and the ruling was against USAASA to indeed pay. And Chair, we are looking at various ways on how we are going to resolve this, whether with our attorneys, whether through an appeal or any other legal means. We can move to the next. Related to the same service provider, Chair. Related to the same service provider, thank you, Siko. It is the matter, again, on the fluctuation of fees or exchange rate. In any contract of this nature, Chair, hedging would be something that organizations enter into. However, Lerata Dima is now claiming a claim of 198 million towards the hedging, which the service provider should have really pursued in terms of their contract at that time. So even this, Chair, is still sitting with the courts, and it will be deliberated accordingly. If we can move to the Lerata Dima, the next Lerata Dima matter. The other matter, Chair, is we've now concluded the Lerata Dima. We have a KST trading matter where they are demanding also escalations related to the installations. USAASA was paying installers for installation for 550 in the urban areas and 650 in the rural areas because of the complexities that installers would then need to face with when coming to install in rural areas. And so this matter is related to that. Pleadings were heard and were closed. We are now waiting for the matter to be enrolled in High Court. It is a claim against USAASA for 1.8 million. We have another claim, Chair, also related to the Cs. I think we've concluded the claims against USAASA when it comes to the procurement of the set-top boxes and related to this BDM program. We then have a matter that is currently sitting with AFSA, and that is the broadband connectivity for service provider Groma Kosikati. This for a rollout that took place in Nyandeni and in Bentley local municipality. Chair, due to the open review that the agency instructed from 2020, which ended in 2021, we then could not be able to process any invoices that were related to any broadband because we were reviewing the entire broadband, how the service providers were acquired by the agency. Also linked to that was an assessment on the actual broadband and the connectivity that happened in the sites that were earmarked. So due to the open review, the agency delayed to indeed pay, and the matter is currently sitting with this. We have contested with the service providers the amount, and that's basically the reasons why we find ourselves in court with the service provider, because we see that though the claims are valid, however, there's sites that they claim for that were not connected in certain areas for the periods that they now claim. So this is one of the matters that, Chair, we are still engaging with the service provider through the lawyers to settle this matter out of court, because the agency was willing to pay at the time that the service provider took us. So, Chair, and then we have one more a related issue that we have as USAASA passed on to National Treasury for further investigation, and it is the procurement of Ssb that was done, Chair, through EOH. That investigation is currently sitting with National Treasury. There has been some delays, Chair, in the dependencies that we having National Treasury, who then goes through their own processes in terms of procurement of their own service provider that does the investigation. So we are really just waiting for National Treasury. Frequent reporting is being provided by National Treasury to the board with regards to this matter. So this is something that we've also highlighted to National Treasury in writing, that it has been ongoing for some time, both the Bright Wave, which is connectivity, and these ones which are looked by National Treasury. They have been going on for some time, and we are really pressing the National Treasury to conclude this matter on their side. Chair, I think this concludes our high-level presentation with regards to our litigation reports and the labor matters that are currently sitting in various platforms. Thank you, Chair. Thank you.
I take it that Mr. Omega, you don't have any matter you wanted to get back to, so that we can then get to the engagement.
Chair, I think we can proceed with the engagement.
I will then, without waste of time, check members who would want to engage with the presentations. So the committee support will then assist me in case I do not see the hands. May I then take hands?
Chair, my hand is up, Honorable Mthembu.
Okay, Honorable Mthembu, you are noted, followed by Honorable Bodlani. Might just check if there's any other hand I may be leaving after Honorable Bodlani. Let's take those in the meantime. Honorable Mthembu. May we also request Honorable Kubeka just to mute your mic is yeah. Thank you. Honorable Mthembu, you now recognize, you can proceed.
Thank you very much, Honorable Chair. Please allow me not to switch on my video camera due to the poor connectivity on my side. Chair, firstly, I just want to welcome all presentations and also have a question directed to USAASA. On their presentation, they did mention that a number of cases are still sitting in court. I just want to check whether are there any legal cases that can be addressed outside court. That is question number one, Chair. Question number two, I want to check what is the estimated cost in terms of financial impact in defending all the court cases mentioned in the presentation. Thank you, Chair.
Thank you, Honorable Tim. Honorable Bodlan, you are recognized, can proceed.
Good morning, Chairperson, and thank you for the presentations. Chairperson, we welcome the ICASA presentation, and indeed we congratulate the entity on being able to finalize the sale of the spectrum. The presenter spoke about lot IMT 800, which he then says there should be a population of 99% reached by the service provider, and that one was left unsold, if I understood him correctly. What then happens with such spectrum if we are not going to have service providers that can comply with the regulations? And what does it mean for the purpose of spectrum rollout, with it being expected to improve jobs and everything? So if you could just please take us further on that. And the presentation also made mention of the payment of by an outstanding buyer. Is he at liberty to tell us more on that? We did not even get the name of that buyer who has an outstanding payment. Lastly, on ICASA, Chairperson, one of the obligations for the service provider, for the service providers, is for them to have social obligations. What monitoring tools are there to make sure that these social obligations are indeed carried out? Because if I understood Dr. Gabetsu, it is part and parcel of the sale. It's part of and parcel of the sale agreement to say there should be some social obligation. And that social obligation, where do the SMMEs fall in? Because one of the mandates of ICASA is to make sure that there's SMME development. With the sale of the spectrum, I did not see that coming out. If you could just please take us further on that. On the second presentation, Chairperson, I echo the words of Honorable Kubeka in terms of the legal costs. It sounds like it is a lot, and it is worrying that all these legal battles are happening with one particular company, because all we had was Lerata Dima and Lerata Dima. So that is really worrying. And when you get a presentation and you are told that matters are sub judice, that sort of makes you mood. But Chairperson, noting that the entity is winding down and we have all these outstanding matters with which are now sitting with the courts, perhaps, Chairperson, there could also be a legal advice on the part of the portfolio committee to say, how do we handle this? Because this has been presented to the portfolio committee and it feels like our hands are tied, especially on the sub judice matters. But equally, when you hear about officials who are then suspended, and the presentation did not quite articulate the link between the suspended officials and the litigation that is currently taking place, if at all it is there. And that is where I will end for now, Chairperson. Thank you so much.
Thank you, Honorable Bodlani. May I just take from the committee support if there may be hands I've not seen, so that I can give
nothing on my side, Chair.
Okay. We'll then take the response on those questions that would have been asked. And if there are follow-ups, we'll then take the other hands thereafter.
All right, thank you, Honorable Chair Maneli. Thanks for the compliments, honorable members. I think that the more pointed questions came from Honorable Bodlani. So I will deal with the question of the outstanding buyer, as you termed it, as well as the SMME part. And then CEO will just come in briefly to deal with the unsold lot and the obligations. So the buyer that we are still finalizing the balance of the payment with SLC. So I think that's all I can see. But as I've indicated, they have paid. It is just that there is the balance that is being finalized as matters stand, and I believe it should be concluded soonest. On the SMMEs, I think it's an important question. When we look at spectrum auction and the fact that spectrum has been bought by incumbents, it may appear that there is no angle or aspect of SMME development, but procuring spectrum is the one part. With this spectrum, there has to be network rollout, and that's where the bulk of the economic activity for SMMEs will be. So we are pushing through our regulations, we are pushing through, oversight to say, operators, please make sure that as you procure, as you build networks, you involve SMMEs which are compliant with our BEE prescripts in the country. So we should not only look at it from a perspective of what has been procured at auction, which is spectrum. On the back of it, that's exactly where the real SMME opportunities lie. I mean, we always look and get financial results of our licensees. They spend billions annually on network expansion and network rollout. And it is ICASA's role to make sure that we encourage pro-transformation procurement in the sector. But it is also the responsibility of all other institutions, including moral suasion when everything else has been done. Moral suasion to operators to say, can your procurement really reflect the structural demographics of our country? Can your procurement as you roll out networks really show that you appreciate the historic background and context in our country, where we come from as a people, and can it have the spirit of redress? So there is a lot of potential for SMMEs from a network rollout point of view. And by the way, the CEO will touch on it, but it's one of the reasons why Lot 9, the lot that I referred to as Ansul, is not only about obligations, but it's also the realization that the reserve price was close to R1 billion. We do still believe that that particular lot has value in it. And operators may have realized that if we buy this at this amount, at what stage are we going to roll out, given the other spectrum lots we have participated on. So there is a lot of scope, just in summary, for SMME development, because on the back of this raw network capacity spectrum that has been bought at auction, we need deployment in the outflung rural areas of our country. I mean, the connectivity that I referred to of police stations, clinics, and traditional offices and so forth, it requires SMMEs to go out there and deploy services. So respectfully, as Parliament, as the committee, as ICASA, the minister, and everyone involved, we need to then appeal to the corporate citizenship conscience of our operators, that as they embark, over and above what the regulations say, but as they embark on this network rollout and investment, can they really pay serious attention to the development of SMMEs in the country? CEO, please briefly respond to the lot 9, the unsold lot, and the obligations. Thank you.
Thank you, Chair, and good morning, Honorable Chairperson and Honorable members. Perhaps to start off with the obligations, I think the question was, what are the monitoring tools that are in place to ensure that those obligations are fulfilled, or to ensure that there is compliance with the obligations that are imposed? I think, Chair, we have outlined in slide 11 that the social obligations relating to the connectivity to the various public institutions are still in the process of being finalized. So if we look at the type of institutions that are to be connected, public schools, clinics, police stations, traditional authority offices, police stations as well. We have come to the realization that there needs to be engagement, firstly with the Department of Communications and Digital Technologies, but also with all the other government departments that are in charge of the different institutions that we have outlined. And those consultations are basically to agree on the model of connectivity and the specifications that are to be provided to each of those institutions. The intention is that the consultations will be concluded by the end of this year, and the allocations of the institutions to the different licensees with details about the nature of connectivity and the specifications of connectivity that is to be provided, also finalized by the end of this year. All of the licensees will then be required to report to ICASA on a biannual basis in terms of progress of how they are doing in connecting the institutions that would have been allocated to them. And I think post the completion of connectivity, the obligation will then be on ICASA as well as the different oversight departments to monitor that the facilities that are connected continue to be protected and that they continue to remain functional and service the stakeholders that are intended to receive the service from them. So the monitoring lies firstly with ICASA to ensure compliance by the licensees, but also we would expect that as part of this consultation with the different government departments, they will also share the responsibility of overseeing that those facilities indeed serve the purpose for which they are provided. On lot 9, I think the chair has already sort of touched on it. What will happen to that lot that was unsold? So primarily, it would appear that the reason why the lot remained unsold was the reserve price, which was in excess of 1.1 billion rands. And the second reason was the coverage obligation that accompanied the spectrum, which was the requirement that whoever was going to get that lot must provide 99.8% population coverage within 5 years of issue of the license. And the understanding appears to be that all of the licensees or the bidders saw that as being prohibitively expensive for them to make a return within a reasonable period of time. So they then didn't want to bid for it. As to what will happen to the lot, ICASA has since pronounced that we will commence a new licensing process to license this lot. Again, it will be a transparent and an open process, which will obviously take into account the outcomes of the auction that has taken place in terms of the assignments to the current industry players. And it will also then take into account the need to then ensure that there is a competitive landscape that is maintained going forward, specifically in respect of how the sub-1 gigahertz spectrum is licensed. So the intention is that there will be an information memorandum issued within this quarter or within the next quarter to initiate the licensing process for the lot 9, which remained from the auction. As to what obligations will accompany the lot in the new licensing process, I think that will then be informed by the outcome of the engagements that will take place when the consultation process starts with the publication of the information memorandum to initiate the licensing for the unsold lot. Thank you, Chair.
Thank you. That takes care of our responses, Honorable Chair Maneli.
Thank you, USAASA.
Thank you, Chair. So the honourable members asked if there were matters that we could resolve outside the doors of court. Yes, there has been about 2 matters we've already struck off, and we were able to resolve those outside of court, and that its own was sitting around 100 and odd million, and that we were able to settle outside of court with no legal fees, just a service provider speaking to us and us coming to the party as such. We are also, as I said in the presentation, that with regards to the connectivity case, we are still pursuing the service provider to be able to just settle this matter outside of court. It is in our interest to do so, Chair, and just to also bring about this matter, the cost associated that we have estimated to resolve or defend ourselves is around 12 million that we will spend, but the overall cost of all the litigation bill that we're currently sitting with is just about under 400 million. Yes, it is worrying, and this is why I think the board had taken an undertaking together with management to try resolve these matters outside of court with speed, looking at the fact that also we are in the process of dissolving. So we are doing everything in our possible power to really try to resolve these matters outside of court. And there is absolutely no link, Chair, to the litigation report that we've just given and the suspended officials. The suspended officials were on a financial misconduct, a possible financial misconduct that was linked to a service provider, also linked to a sister organization, SAPO. So that, Chair, as I said, that the matters are currently in a very advanced stage where all the parties have been interviewed, and now we're just waiting for the final report from the investigators that are working on this matter. Chair, I think I have answered all of this. Our interest is to really bring down this bill to as close as nothing before the dissolution. So we are looking at other ways, Chair, to resolve these matters, and our legal also are looking at other ways to resolve this matter. So these matters are before us and are worrying, but we are looking at those, considering that we would be winding down and we would not want to go to the department. I think our liability remains very high in this regard. Thank you.
May I then check with the honorable members, firstly, with regard to follow-ups, if Honorable Mthembu has got follow-up questions, having received responses, and Honorable Bodlani, and thereafter I'll check if there are still members that would want to ask further questions before we wrap up.
Thank you very much, Honorable. Thank you very much. Actually, it's not a follow-up question, but I just want to appreciate both the presentation of the entities. They are clear and straightforward. But on ICASA, Chair, I just want to say ICASA need to establish a sustainable one and be used as an instrumental for transformation. Yes, Chair. I think that is it. Thank you so much.
Thank you, Honorable Mthembu. Honorable Bodlani, you are covered.
Maybe a brainwave, Chairperson. Chairperson, I listen. If you will indulge me, listening to the response on the social responsibility of of ICASA, it is clear that ICASA is not mandated for such things. And I think mine would be on the response from the CEO and the chairperson is to say there really has to be a deliberate interactions in terms of intergovernment relations, because it is not their key mandate. But if we are going to say to BOSLC or MTN that this is part and terms and conditions of the sale of the spectrum, that you have a social obligation, then there should really be a way, and I'm the first to admit it is not their commandate. There should really be proper intergovernmental relations that we can then be privy to, so that we do not have terms and conditions in terms of the sale, but they mean nothing to the men on the street. Thank you, Chairperson.
Thank you, Honorable Bodlani. May I then check if there are members who want to ask questions? Honorable Mtembu, if you can just mute.
Sorry, Chair.
Your mic, yes. Thank you, Honorable Mtembu. I just wanted to, as I said, to check if there may be other members who would want to ask further questions. So if not, I think as ICASA may want to respond if they want to, but as you respond, you'll take into account the comments made. So I just want to check if you really wanted to have a specific matter to respond to. Otherwise, one could cover the way forward in the summary.
Thank you very much, Honorable Chairman, and honorable members. We note the inputs made, and we will continue doing our part, and we urge everyone else to help and support. But yeah, we take the inputs in a positive light. Thank you.
Thank you. I think honorable members has come to the conclusion of the two presentations. I think there's clarity there with regards to ICASA, and I'm sure you as you take it back, there is a point there about the WOM, and we really appreciate the commitment made that every effort is being done to ensure that you would have it in a sustainable way, so that we do not only say that it is an instrument for transformation, but Blacks in general and Africans in particular, as those that would have been previously disadvantaged, should also see it in that way, as it impacts positively on their lives on the ground. And I think this is the point that's also made with regards to universal service obligations that gets imposed to those that are taking the spectrum. That even on that point, I think the emphasis is really to say it should be indeed about still advancing our development objectives, and in that score, strengthening intergovernmental relations get to be important, so that that positive impact it's also seen at different levels. I think the point to make in emphasizing that point, it's really that when people fail to implement the service obligations that they would have agreed to, it's understood that penalties would kick in. But we need to be quite careful that the penalties may be quite smaller in terms of the developmental value if those service obligations would have been implemented. So in supporting yourselves, I think as part of our oversight, it's something that we would want to look into, so that we do not do this to comply, but in the real sense, they should be about advancing our development objectives that we have set for the country. As it relates to the timelines, we did understand you, Chair of ICASA, quite well, that we also need to give it time so that we do not cut corners. I think we support that approach. However, we should at all times put this pressure that as we do that, it shouldn't be taking us the time it took to be where we are today because of consultations and so on. I think the consultations as they are done, in the main, it's all about ensuring that the impact should be felt on the ground. And surely as it relates to it as a transformation tool, those who stand to benefit out of that may not have the patience for many years to come. So I think working with yourselves, as well as the department, because we also do know that whilst you may be working hard in looking at these models elsewhere, in terms of how they've sustained a structure similar to one, from a policy directive point of view, it will still be the department that must look at that through the ministry. So we'll also implore them to really look at fast tracking that so that those who stand to benefit should really see that we are indeed committed in ensuring that that benefit could be realized within reasonable time. As far as USAASA and USAF is concerned, I think as you would have heard, there is indeed concern that things may need to be fast-tracked in resolving these matters, including where possible. Of course, look at options of out-of-court settlements, but of course, where it's not possible, indeed, we'll have to wait for courts. But I think from the committee side, would also appreciate honorable members that most of the things we're dealing with, the cases and so on, are matters of the legacy other than things that would have happened now. And what that should tell us is that at least we should also be assured at all times that the mismanagement of the entities as it's shown in the reports would not be something that reoccurs as we move forward. So this does not apply only to USAASA, but generally how we look at entities that report to the portfolio committee here, that it should be about drawing lessons in the main as we are trying to resolve these legacy questions, but that we assure South Africans that there will be no reoccurrence of such. And that as we look at people that we give responsibility of governance in these institutions, we would also be looking at the best that South Africans could offer in turning these institutions around, but also assuring South Africans that will not have these governance challenges in the future. Otherwise, as it relates to consequence management, I think there's appreciation, as you would have said you've heard from members, that you are taking action, and we take it that the department would look at this quite closely, because if not, you may wind up USAASA, place them with the department, but the liabilities may just be too huge for the department. So entity oversight, please take note of that. So that would be the summary, honorable members, in closing these presentations. and that from the committee side will be able to make necessary follow-ups on the summary that has been made as a way forward for the meeting. I take it that that captures your way of looking at it as the portfolio committee, and that the entities would have taken note of those. With that having been said, of course, because we're going to move to the next item, I must take the opportunity once again to thank the department as well as the entities as led by their boards and or council and the executives, and that you can be released if you so wish as we get to the next item, so as to give you space to implement and then come back next time, of course, with progress. So we'll release you if you would want to. Thank you.
Thank you, Chairperson.
Thank you.
Thank you,
now,
Chair.
honorable members, thank you. We'll now
Thank you,
move
Chair.
to the minutes as we usually do. Would go on a page by page, and members could raise whatever they would want to raise as corrections. If there are no matters raised as corrections, including on the noting and resolutions, honorable members, I would now for formality just get a mover and a seconder for the adoption of minutes.
Chairperson, I move.
Honorable Bodlani moves. Can I get a seconder?
Second, Chair.
Is that Honorable Dr. Basu?
Supported, Chair.
The minutes are seconded. Any objection in us adopting the minutes? Thank you, Honorable Basu. So no objection, so the minutes are adopted as true reflection of previous meeting. I take it the portion agenda, that would be the last item.
That is the last item, Chair. But just a reminder to members that the meeting next week clashes with plenary, Chair. Thank you.
All right, so if that's the last item, this is the point I wanted to raise, honorable members, that with the changes in the parliamentary program, our meeting for next week is affected by plenary that starts at 10, and therefore would need to reschedule. It's a matter we may want to have a discussion with the House Chair's office on that, and would advise members accordingly. And I'm sure if you look at the program, this would have been a situation where we would have SAPC coming before us as the committee next week. So we'd have to move that for another day, given the changes in the parliamentary program that needs all of us to attend the plenary on the same day. So would advise members accordingly after getting some direction from the House Chair in terms of amending our program. With that, honorable members, once again, thank you for your participation. The meeting is adjourned. until we see each other again. Good. Thank you.
Thank you, Chair.
Thank you, Chair.